assuming that the light was green, was the law correctly applied to that fact?
Okay, that green and red light. That's a great analogy. I mean, that's really the best way anybody, including my law professors, by the way, ever explain that. Because it's a difficult concept to, sure, I don't care who you are, to wrap your head around to some degree here. Okay, now how does a trial judge? I really am searching for a word other than screwed up, but I think that's an accepted term if it would be. You understand what I'm asking you? How does a trial judge make a mistake on applying the law that you and your colleagues are going to come back and say, yeah, we agree the light was green, but you should not have, and I'll let you finish.
Well, it's probably a concept that the laymen, non-lawyers, aren't as familiar with, but the law isn't as clear as you might think it is. And there are always questions coming up about, well, what does this mean? What does this statute mean when it says it uses these particular words? For example, we had a case a year or so ago where a defendant was convicted of trying to procure a minor for purposes of sex, he was convicted in the trial court, but there really was no minor in this case. It was a kind of a sting operation where there was an adult who was pretending to be a minor.
Yeah, which we hear about happening on the internet all the time.
And the question was, did you have to have an actual minor under this statute? The trial judge determined that you did not have to. We looked at it, thought about it, did a lot of research, and we concluded, yes, you do have to have an actual minor. That was one of our cases that did go to the Ohio Supreme Court. Interestingly, in the meantime, the legislature changed the statute to make it clear that in the future, you would not have to have an actual minor, that you could have an adult pretending to be a minor to get a conviction. So the legislature fixed what they saw was a problem, but the Ohio Supreme Court said that we were right as the statute was originally written.
When that
you had to have an actual minor to have a conviction.
Okay.
So it's and it was not a question that was clear on the face. We had to do a lot of thinking and studying to determine that.
Well, our lawmakers there in Columbus, our senators and representatives, are trying to do the best for all of us.
Absolutely.
And it all comes down to words, and folks like you need to make that interpretation. Judge, when you say as an appellate judge a case is remanded, what does that mean?
Well, it means we're sending it back to the trial court to do something. Sometimes we may say that there has to be a new trial. Sometimes in a criminal case, it's just a problem with the sentence, and so that the defendant has to be resentenced. Most times when we reverse a case, we do send it back to the trial court. There are some rare situations where we reverse and we enter the judgment that the trial court, in our opinion, should have entered, but it depends upon specifically what the question was that we were deciding.
But when we talk about a reversal, in other words, that's a case where you looked at it and said, no, I'm sorry, but you had to have a real minor there.
Yes.
Okay.
Yes. Well, now that was one that was not remanded because there was no real minor. There was no reason to send it back to the trial judge as we interpreted the statute, as the Ohio Supreme Court ultimately agreed with. This fellow just couldn't be convicted under that statute.
Okay. All right. But
he could have been convicted under a different statute, by the way.
Yeah.
But
and if like circumstances there with different litigants, or even if this same guy chose to do it again,
exactly.
It's a different law, and that's the law is alive, and it has to keep changing. But the short answer, when you your court remands it, when we hear on the reading the paper it's remanded, you're sending it back to the trial judge
to do something.
Yes. I mean, something that you found an error with, and you're going to have to correct it. Does that necessarily mean that he's got to start all over again?
No, it depends upon what the mistake was. It goes back to the trial court at. It shows up in the trial court at the same spot it was immediately before the mistake was made.
I gotcha. Okay, so if it was a matter of sentencing,
it would go back to be resentenced.
You're saying to the trial judge, you're going to have to revisit that, and you're going to have to give a different sentence.
Exactly.
Judge, constitutional issues, which is something we hear a lot about. We're all real interested in. Fourth Amendment search and seizure, Miranda, you have the right to remain silent, whatever. What is an example of a constitutional issue that might cause you or your colleagues to reverse a case?
Well, the example you gave is probably the one that we see most often, the search and seizure cases, where the question is whether the police had a probable cause to search a house, a car, whatever, that's the constitutional question we see most often.
That's a big one.
Yes.
That's a big one.
Yes.
So the trial judge and the jury said, yeah, I think the search was fine. You're convicted.
Well, with searches, it would just be the trial judge.
The trial judge. Well, that's right. It would be. It's not an issue of fact.
Right.
He lets it in or he doesn't on a suppression hearing. Under a hypothetical, it comes to you and your panel and says, no, we don't think so.
Right.
So
we have cases where we've disagreed both ways.
Sure.
And sometimes the judge has allowed something in, and we decided that was a mistake. Sometimes the trial judge has kept something out, and we decide that was a mistake.
And it's right at that point that we sort of start all over again.
Exactly.
We move from this point onward, but it's out now.
Yes.
So deal with it,
yes.
Whatever. And I guess the prosecutors are somewhat involved in that, too. You may not have a case after that.
Well, that's right. It's one of the few times in a criminal case where the prosecution can appeal. If the trial judge suppresses evidence, the prosecution can seek leave from us to appeal that question before the case moves forward without the evidence.
Well, it's pretty obvious in talking to you today, albeit you're over in Akron and we don't see you as much as we do our local judges, but you're very, very much a part of this process. I'd certainly like to thank you and invite you to come back. I'd love to talk to you some more about this, and if you'd be so kind, we'd love to have you.
Sure.
So thank you so much. If folks would like to see this episode of Law Talk with Judge Dickinson, they can go to our website at www.CZ-CLEP or CZ-CLEP.org to see the judge's show and other shows that we've put on. I am John Celebrezze, and I thank you for tuning into Law Talk.
To keep up on Medina County and other legal issues, go to www.CZ-CourtReporter.com, a function of the Celebrezze Zanghi Community Legal Education Project. At CZ-CLEP, we're devoted to the education of today's legal issues. Fueled by the public's keen interest in our legal system and current events, CZ-CLEP is dedicated to the educational venues aimed at enhancing the understanding by all citizens. For a complete listing of dates and times for this telecast, tune in to WCTV Channel 15 or log on to WadsworthCity.com and follow the links to WCTV.
I'm John Celebrezze. Please join me in getting a better understanding of the law.